Required a quorum. Apologize for being a little late, but the quorum was a little late.
Okay.
This is the meeting of the Ventura County Campaign Finance Ethics Commission. I have to read it. And we'll call the meeting to order. I think that we have everybody here but Ms. Jones, and we expect her, but she's not here yet. Does that do for roll call?
It does.
Number 3, review agenda. Agenda is any revisions or ratifications, inclusions, etc.
Not that I'm aware of.
Number 4, the approval of the minutes of the meeting for May 11th, 2007.
I reviewed the meetings and move to approve.
Jane, if you don't second, we're in trouble. Thank you. Okay. All in favor? Aye. Opposed? None. Number 5, public comments.
We do have a card.
We do. Okay. Okay. Mr. Williams.
Thank you, Your Honor. Geraldine Williams, 62-year resident. I don't think you'll be receiving any more legislative intents from Supervisor Bennett or the other supervisors. I delivered your message to them in pretty strong, blunt language. And so I don't know if they've communicated with you or not, because it's not against the rules to communicate with you. So what I'd like to discuss, Supervisor Bennett announced June 26th in the two papers, the Los Angeles Times and the Ventura County Star, that he was getting an early start as a candidate. So I reviewed Election Code sections 304 and 305, and I find that he is in violation of that, and I find that he is in violation of the ordinance under section 1264 definitions. A county candidate means any individual who is a candidate for supervisor, etc. You cannot be a candidate for supervisor, and this ordinance ignores the Election Code section 305. You cannot be a candidate under state law until you have done one of two things or both: signed a piece of paper under penalty of perjury that you are a candidate, and for county supervisor that can't happen till February 11th, 2008. Or that your signatures to be nominated have been qualified under Section C, and your name will appear on the ballot. So this campaign ordinance, it directly violates the California Election Code. And a county of Ventura is mandated to obey state law. So I find this commission here in a predicament in trying to administer this, and I'd like to reserve my time for number 9, I believe it is. How much time do I have, Madam Clerk?
You've got about half, I think.
Oh, that's perfect. So I'll see you on number 9.
Okay. I don't think, Mr. Williams, that we have jurisdiction over that from this commission. It's campaign finance.
Let me clarify your question, Your Honor.
Sure.
The question that I'm raising to you, this has defined county candidate. This has defined what a county candidate is. Means any individual who is a candidate for supervisor. That's where the election code comes in. you cannot be a candidate for supervisor until February 11, 2008, after you have been properly processed through the election department of this county in regards to the election code, Your Honor. So if I misunderstood, you see what
I don't think we're understanding each other.
we're not.
I'm not saying you're right or wrong. I'm simply saying that I don't think that this commission has the jurisdiction over that. I don't know quite what you want us to do.
Oh, okay, Your Honor. Okay, thank you. No, not jurisdiction, Your Honor. When this ordinance uses county candidate and then describes it as a candidate for supervisor, that automatically kicks in the election code of what that candidate is or is not. And maybe I should put it in writing and put it on your correspondence agenda then?
You certainly are welcome to do that. I'm simply saying I think it ought to be addressed to somebody else. I'm not sure who yet.
Okay, but okay, help me with one thing. Under Section 1264 definitions in the ordinance, this is your ordinance. How does the commission handle that definition, Your Honor? In the ordinance, which you are, your body has the authority to administer. That's my question to the commission.
I'm sorry, I'm not sure I understand.
I'll understand, and I'll clarify, and I appreciate. I'll clarify that in writing.
Okay.
Thank you, Your Honor.
Thank you very much. Is that a video camera too?
Yeah. And I'm a DVD man now.
Okay.
Thank you, Your Honor.
You're welcome. Item 6, commission members' comments.
I have no comments at this time.
Okay. Number 7, consent item agenda. We've got, that's 8 and 9. Yeah, item 9 you wanted to be heard, Mr. Williams, am I correct? Okay.
Are we ready for that?
We are. We would ordinarily, I think, just go ahead and approve the consent agenda, but obviously if you want to be heard, this would be the time to do that.
Kildene Williams, you know, Your Honor, you know I respect you. You know I hold you in very high regard.
Thank you.
You have to know that. And, okay. I have Mr. Flynn's letter here. And some of the issues that he has brought up here would appear that this body and this ordinance cannot function with those things omitted. Just take on the back part of the page. Candidates should also be given orientation on those provisions which are especially complex. I'm not going to judge this commission on the last meeting on Supervisor Foy, other than he had no political background. I'm not talking about any merits. I'm talking about being a candidate and the statement here. If it becomes so complex that he could be found convicted but not penalized, I kind of object to that. I believe if we're convicted, there needs to be some kind of penalty. I believe all criminal penalties should be removed. It just doesn't make sense. This is about money. If you're going to breach it, make us pay in money. Forget about all of those complaints I filed that had to go to the district attorney within 24 hours. This is all bubblegum bubbles that just blow and pop, and it makes government look bad.
You got about 30 seconds left.
Okay. And so here again, the definitions that come in here. In my personal experience, the election division is supposed to administer the complaint side part of it. You get it in verbal, nothing in writing, and they told me this, no, we didn't tell you that. This ordinance is so flawed that this commission needs to tell the Board of Supervisors that. Thank you.
Thank you. No other comments on that. Do you want a motion to approve the consent agenda? Okay, that's items 8 and 9.
So moved.
Okay, moved and seconded. Any objections? All in favor, say aye.
Aye.
Aye. Opposed? Carried. I should have asked him how many 3x5s I could have. The regular agenda, item 10, is the dismissal of the Republican Central Committee matter. Were you the one were the one stopped on the freeway?
No, Your Honor.
Somebody else.
No, that's Craig Steele, the other
Okay.
attorney. Ken Hardy, investigator petitioner on behalf of the County of Ventura, in case number 2006-15. I know you have before you my recommendation of dismissal of the
Yes.
complaint and the amended complaint. I was planning on just going over that in very summary fashion, unless you would like me to go over it in more detail.
I've read it myself, but any of you?
This whole thing. I've reviewed it.
Okay, apparently we have reviewed it.
I'm sorry.
We have reviewed it.
You have
so,
reviewed it?
yeah.
Okay. Would you like me to go over it in summary fashion?
If you feel that would help you, then that's fine.
Well, let me explain. Here's the other attorney. That was we were just talking about
You.
Let me be brief, because I don't want to belabor the point here, and I know Mr. Osborne may want to have some comments as well, to which I may respond. With respect to the original complaint, just in concept here, the issue was whether an approximate $15,000 that was attributed to the Ventura County Republican Central Committee, we'll just call it the Republican Party for short, whether that was deemed a contribution or not to Peter Foy. And based on the original report, there was no indication that it was made for a member communication. I know you probably looked at the member communication government code section that defines that. As you know, usually an amount spent or an in-kind amount of materials or services is usually characterized as either a contribution or an independent expenditure, one or the other. The original reporting in this matter identified it just as a straightforward contribution. That's what kind of triggered the original investigation. To make a long story short, after investigation process and after the Republican Party provided certain information and after further conversations, at the end of the day, based on the evidence that we have, it looks like the amounts were in fact pertaining to member communications of the Republican Party. We don't have any evidence that the communications in question were distributed to non-party members, and therefore, pursuant to their respective government code provision, that would not be deemed either an independent expenditure nor a contribution, and therefore not subject to the contribution limits of the county ordinance or the independent expenditure provisions of the county ordinance.
It's an interesting concept because the Republican Party, for that matter, the Democratic Party, are large, really large organizations, and I could easily make the argument that if you put out your recommendations on who to vote for, that you're putting it out to the general public, notwithstanding, because it is such a large organization, but apparently not.
Well, I should add, part of the length of this investigation is that I kind of simplified the issue. There have been discussions at the state level with legal staff of the FPPC, the Fair Political Practices Commission, about interpreting certain provisions of the Political Reform Act in such a way that some of the activity, in this case, for example, might have been a problem. Not all of it, but some of it. In terms of tracing contributions and the contributions to the Republican Party, is that subject to limitations and so on. Certain proponents certainly were hoping that the FPPC would interpret the existing law in such a way that they in turn could interpret their local ordinances more restrictively. Well, the FPPC pretty much did not agree with its own legal staff to go there and decided this is probably, and I think it was probably a prudent move on their part, this is complicated enough and serious enough where if we're going to change, this should be done with new regulations, and there's a new bill pending out as well dealing with this issue. So given that the FPPC kind of backed off on any type of aggressive interpretation of its own laws,
We shouldn't go ahead.
I believe it's
with
prudent that the county take the position that we interpret our own ordinance accordingly, and therefore that adds to the
I
recommendation.
could see somebody setting up an organization consisting of all the registered voters of the county.
Well, I mean, there are proponents that have a problem with this whole idea of member communication, particularly with the political parties, but we'll wait and see how that works out. But of course, both parties are very interested in maintaining their own control. I mean, this is not really particularly relevant to this proceeding, but just for your information, I know both parties are interested in maintaining as much independence as possible with respect to member communications. So that disposes of the original complaint. With respect to the amended complaint, I should just add that amended filings were made, and based on the information in the amended filings, it appears that there were no violations of the ordinance with respect to the 3 items that I identified as potential violations. I don't think it's necessary to get into those individual items unless any commissioner would like me to do that.
I have no.
I am aware that, and Mr. Osborne may discuss this somewhat, that the county itself can't force people to actually make these filings, the state level filings. The county uses these state level filings to see if its own ordinance has been complied with or not. That's kind of an interesting technical issue that may be brought up, and I might revisit it if necessary today, based on Mr. Osborne's comments. But I just would like to conclude that based on the amended filings, which I was happy to see that they did do, it didn't appear that there were any violations, at least with respect to the county ordinance.
Any comments or any disagreements that we should follow the recommendation?
The only thing that would not be to members would be the ads in the paper, but I didn't notice whether. I'm sorry, I didn't do that.
While you're up, let me file.
There was ads in the newspaper would not be, but they were small.
The ads came under a different problem, I think. Isn't that it?
And the newspaper ads in question appeared to be the amount of money spent on the newspaper ads in question were under the county's $1,000 reporting threshold.
Right.
Okay. If not, do we need a motion? I note there's something here for me to sign. Do you want that?
I do know that Mr. Osborne is here, and I understand he probably wants to make comments before.
Sure. He's representing.
Okay. You don't want to snatch victory from the jaws of defeat, do you? No. I mean, the other way around, excuse me.
No, I respect Mr. Hardy. I'm Mike Osborne with the Republican Party,
yeah.
And Mr. Hardy and I have had many spirited conversations about this. The only issue I would like to make sure that everybody's aware of is that we attempted to cooperate at every juncture and did everything we could to try and help the investigation and have it come to completion as quickly as possible. we always felt that this was the outcome we were going to reach. We knew that what we were doing was covered by state law, and in fact put in place by state law to cover just the kind of activities that we undertook. And in fact, I've had a communication from the district attorney's office that they came to this conclusion some months ago, that everything was proper and nothing inappropriate had taken place. I should make the commission aware that there are laws circulating and have been authored in Sacramento, as Mr. Hardy alluded. However, the statute, or what they are proposing now, strengthens the member communication issue, and in fact makes the removal of local jurisdiction even more clear. It's not going the other direction. And the same people that put this kind of statute in place are the people that came up with our campaign laws in the first place. I mean, it's the legislature and the governor of the state of California who have put these in place to do this, and they allow for the communication of the parties with their membership. And what you propose couldn't take place unless people were to join the all-county party. And so it doesn't really represent any kind of a threat. Yeah. I want to thank you for your time. I know it's been a long, arduous process.
No, well, thank you very much for your cooperation. We very much appreciate it. We aren't trying to grind any axes one way or another. We're just trying to be consistent.
Oh, I understand. And Mr. Hardy's been fine. He's been, as I say, we've had many spirited conversations.
I have no further comments, Your Honor.
Okay, thank you. Do we need a motion as well as my signature? Okay. Anybody want to move
Yes.
that we follow the recommendation?
Yes, I move that we follow Mr. Hardy's recommendation of dismissal.
Second.
Moved and seconded that we follow the recommendation and take no further action on item number 10. All in favor? Aye. Opposed? Carried. Would that things worked this easily in Washington? Well, no, but I mean, that's it. That's with trying. I mean, this stonewalling is just on both sides.
It helps that we don't have political agendas, Your Honor.
I hope so. If we do, we shouldn't be here. Item number 11. Your car is still broken down, or did they fix it?
In a stunning reversal of my normal automotive luck, Mr. Chairman, the Auto Club was able to fix it and get me going. So,
Oh, hallelujah.
apologize for being.
No, it's all right. It worked out.
The timing worked.
The timing was perfect.
Thank you. Mr. Chairman, members of the Commission, my memo is fairly straightforward. Pursuant to your operating procedures, I'm required to seek authorization to investigate an additional issue in these two related, almost duplicative complaints, and that is the issue of whether contributions that are now being characterized as having been made by spouses on a joint check were in fact documented as such at the time they were made, and whether the writings that are required to be kept under state law were in fact kept by the committee and the contributors at the time. This is not in any way intended to be an indication on my part that I believe a violation has occurred. This is merely a request for authorization to investigate whether, in fact, that violation did occur, because that particular issue falls outside of the complaint that was originally filed.
Is there anybody in the audience or anyone from the Commission that has any questions or wants to be heard? If not, we need a motion, I think, don't we?
I move to authorize Mr. Steele to investigate the 2 additional potential violations stated. Do you want my motion more specific? Failure to provide written attribution of spouse family contributions made in a single check pursuant to Ordinance 1274A, and failure to provide access to records, Ordinance 1293.
A second.
Second.
Moved and seconded that we approve your request. Any opposed? All in favor?
Aye.
Thank you. Thank you very much. Hopefully your return trip will not be... I go down to L.A. all the time. I finally bought a new car, not because my old car wasn't running fine, but I just would get nervous thinking I'm going to lose a water pump when I'm in the middle of, it happens.
That has a certain attractive appeal, Your Honor.
Item number 12, recommendation from the Board of Supervisors regarding amendments to the campaign reform ordinance.
Chair Peck and members of the commission, actually this is an item for your commission to consider recommending possible amendments to the ordinance, and arose from discussions at your last meeting where there was a statement of intent provided by the Board of Supervisors on Section 1269C, and that was in reference to the Peter Foy complaint that you resolved at your last meeting. And there was some concern that you expressed that the ordinance should be more specific in terms of the language, and direction was noted in the minutes.
Yeah, it seemed to me that they were following a rule that wasn't technically in the ordinance.
That was the concern of the commission, was that
Yeah.
the language actually did not exist in the ordinance to specify a grace period and a finding of no violation. So staff has provided to you some potential language that you might consider recommending to the board on the 3 sections that were discussed at the last meeting. Section 1267, contributions for non-participating candidates, 1268, contribution limitations for participating candidates, and then the Section 1269C that the board had provided their statement of intent on. And that's shown on your attachment A. Mm-hmm. And again, this is just for your consideration. You may either choose to forward some type of recommendation to the board for their future consideration, or you may choose not to do that. It's up to you.
Okay. Any comments from commission members on this?
Well, I am having trouble finding attachment A. Okay.
It's
Okay.
on the second sheet.
That's it.
Very good.
Yeah, they appear to me to take care of the problem.
Yeah.
Exactly.
Right. So,
Mr. Chair, may I comment?
Yes.
This issue came up in conjunction with the complaint against Supervisor Foy.
Right.
And at the time, staff had presented to your commission a statement of intent that had been made orally at a Board of Supervisors meeting by Supervisor Bennett, which concerned Section 1269C, which is a provision of the ordinance that deals with contributions to candidates and committees that contribute to candidates. And it basically deals with contributions to by an individual to multiple committees. Somebody might contribute to a candidates committee. They might also contribute to an independent expenditure committee. And the statement of intent concerning the 5-day period was specific to that section of the ordinance, not to the contributions solely to candidates under 1267 and 1268. But based on that, your commission gave some direction to staff. But what I would suggest as an alternative approach to this, and upon further contemplation of this issue in the time since the last meeting and with some other discussions in mind, is that your commission basically made an interpretation in conjunction with the complaint against Supervisor Foy of the ordinance as it now exists. And that interpretation could guide further cases as well. And that if the Board of Supervisors disagrees with your interpretation, they could revise the ordinance to correct
ultimately
that.
You're right.
And so that there may, and basically I'm not sure that the changes that we have made now, which were based maybe on some misunderstanding at the time, are really what the board intends. I believe that the interpretation your commission made is in line with the board's intent. That the grace period was not meant to apply to contributions made directly to candidates under 1267.
I don't disagree with that. The trouble is that the intent, I don't think, was in writing. That's the problem I had, is that if you have a vague statute that is interpreted by every public official up and down the state of California, that's not a very good law. And we've had a few of those. Mm-hmm. That was my only I agree that it was, I'll take it on faith, that it was the intent of the board. It's just that it didn't say that.
Mm-hmm. Well, and with that in mind, that unless your commission feels that there should be a grace period of 5 days for return of contributions made to where there's an excessive contribution made directly to candidates, that perhaps you not recommend changes be made to sections 1267 and 1268, but that maybe we could propose a revision to 1269 to further clarify that issue. And the difference would be here that under 1267 and 1268, if an individual makes excessive contributions to a candidate and a candidate receives those contributions, that would be a violation. Whereas under 1269, if an individual made a contribution to a candidate of an amount and then made a contribution to a committee of a certain amount, and combined they exceeded that contributor's allowed contribution, there would be a 5-day grace period for the committee upon discovery or upon the should have known standard that they could return that contribution and not have violated the ordinance.
So, in other words, there are grounds for mistake in 1269 that do not exist in 1267 and 68.
Correct. Because I believe that under those sections, a candidates committee, if they receive contributions from a single contributor that exceeded the limitations, there's an ordinance. There's no grace period that was intended there. Whereas with multiple committees, unless they actually knew that there was an excessive contribution by a contributor, or under the exercise of reasonable diligence should have known, meaning they actually checked out their contributors a little bit, at least to make sure that different names didn't involve the same person. For example, when a corporation that was owned by an individual might make a contribution along with the individual, that due diligence would have revealed that, then that's when the time frame starts, when they should have discovered that, even if they did not, in fact. So I think, at any rate, there might be a little bit of...
we have Mr. Offerman from Supervisor Bennett's office, and perhaps he may be able to clarify that. I don't know.
He may. My point was just to suggest, if whatever your commission wants to recommend to the board, you may do so. I was just proposing an alternative approach that you could also consider.
Sure, and I'm sorry, I didn't mean to interrupt, but I just thought we get another party in this and maybe clear it up.
Sure.
That may be overly optimistic, Your Honor.
I usually am.
I'm Steve Offerman from Supervisor Bennett's office. The supervisor is testifying at a hearing in Santa Barbara County and sent me in his stead. One point we did wish to make is our appreciation for your efforts to straighten out any inconsistencies or unclarity in the ordinance and your efforts to bring additional clarity to areas of the ordinance that may be subject to diverse interpretations. One thing he did want to clarify is that the board's statement of intent that they adopted at his request was specific to Section 1269C, and that it was not intended to address Sections 1267 or 1268, despite its perhaps inartful wording. We can see how others might have interpreted the intent differently, but the express language of that statement of intent that was provided to you at the last meeting covered only 1269C. The issue of grace periods for candidate contributions is a very delicate one, and should your commission believe that ordinance amendments are necessary, we'd simply encourage a very deliberative study of that matter. We certainly wouldn't want to create any situations where candidates felt that they were innocent until caught or something to that effect. We want to assure that violations are clearly identifiable by candidates without resorting to attorneys to interpret the language. And in our very brief review of the language before you, as laymen, it left us more confused than the existing language. Certainly appreciate your efforts to bring clarity to it.
Would you agree with what counsel has been saying?
Yes, I do agree with what counsel said.
So that perhaps where we are now is it merely an amendment to 1269 would be sufficient?
Correct.
Is the proposal in our exhibit? I don't know that you've seen it or
I have,
not.
yes.
You have seen it?
Yes.
Is that sufficient?
For 1269, had no objections.
For 1269 only?
Had no objections to that, yes.
And perhaps what we should do is at least consider just amending 1269 and not 1267 and 8. And that's fine with me. Do you have any questions?
Well, I'm just concerned that we will receive another notice of intent and go through the same situation should this arise again. But I can certainly understand why that language would not be inclusive in 1267 and 1268. So my preference at this point would be to simply accept the recommendations regarding 1269.
And forward that on to the Board of Supervisors.
Mm-hmm.
Okay.
Yeah, I'll support that.
That's all right? That's a second?
It's a second.
Then it's been moved and seconded that we forward on as a proposed amendment to the Campaign Finance Reform Ordinance 4361 for Section 1269 only as set forth in Exhibit A. And is there anybody out there that wants to be heard on it? Okay. And all in favor of that motion?
Aye.
Aye. Aye. All right, passed. Thank you very much. Thank everybody very much. Number 13 is a proposed revision and recommended amendments to the Commission operating policies. That's number 13.
Chair Peck and Commission members, we actually forwarded the strikeout version and clean copy of the operating policies to you well in advance of your meeting. You should have received those separate from your agenda packet. If you need additional copies, I do have some here. They're actually most of them are meant to be cleanup of our operating policies to coincide with the changes in the ordinance that the Board of Supervisors just adopted. Council went through and did quite a bit of revisions. Would the commission members like copies?
We did get copies, and you brought your, I didn't bring mine, but.
This one? This. 13.
There's a thumbnail sketch in our agenda.
The attachment A is really a summary of all of the changes that are contained in your operating policies, all the changes that are being recommended. And if you look at attachment A, it will indicate that, throughout we've renumbered the sections, we've reflected all of the changes when it's referring to the ordinance number to now show ordinance number 4361. Table of contents, we've added a section called rulings and then renumbered. And then going on down, the next section, Article 3, term of appointment, that is to reflect the change that the board made for reappointment of members of the commission. Then Article 3 clarifies what happens when complaints are filed, and that now reflects the fact that there is no longer a probable cause determination process where the commissioners are reviewing complaints. Rather, they will go directly to our investigators to begin the review process and then bring their recommendations and findings back to you. So we've eliminated that entire process that comes out.
Couldn't agree more.
Then you'll see that we've deleted references to volunteers and pro bono attorneys. That's no longer going to be part of our process. We now have our hired investigators. And most of the rest of these items are cleanup, and I don't know if you have any specific questions about them or not. It does indicate that the county executive office has the authority to hire attorneys to do your investigations for you. Clarification about what the role of the petitioner is, and so forth.
Anybody need further time to review or have any questions on these proposals? Ms. Tomei?
No, they just made sense.
Okay. Penny? Take your time if you need it.
Mr. Chair, if I may add something.
Yes.
Many of these changes were made to comport with the recent revisions to the ordinance, so
yes,
that they were be consistent. But in doing so, and having just gone through really our first formal hearing process, we've added some and changed some procedures concerning the hearing process itself, and I just wanted to kind of point those out specifically so that you pay special attention to those in the pre-hearing procedures, which is Article 8, I'm sorry, Article 13, for example. We've added some provisions concerning motions, motions to dismiss, motions that might deal with discovery, and we've added some place some timelines for filing such motions and responding to them. But I would suggest that you might want to pay special attention to those to make sure that those timelines are what you would like them to be as opposed to what I would like them to be. And when you're looking at that, that's something new that we've added.
My only concern on timelines would be that they are sufficient, on the one hand, sufficiently long to give people time to prepare, and on the other hand, sufficiently short so that it doesn't go on forever.
And that was certainly my intent when developing those, and just so you can look at those and ensure that you agree with that.
They appear to be consistent with the Code of Civil Procedure in many cases, correct?
They're similar. I don't think they're exactly the same as what's in the Code of Civil Procedure as far as motions in court, mainly because we are on a different time schedule where motions are filed, and we may not necessarily have a hearing date set. But definitely the intent was to provide sufficient time for the motion to be brought and for the respondent to prepare a response to that, and for your commission to have time to review any such motions before being called upon to issue a decision on them.
And Matt, the Article 18 rulings is a new section as well.
Yes, and that was just to provide a little more set process for the resolution of the hearing process and how that will be documented.
Deliberation, of course, is all in open session. I also noticed that the term probable cause has been completely eliminated from the policies.
You know, that has to do with the fact there's no probable cause hearing any longer,
Right.
which takes away what always embarrassed me slightly, and that was that we found probable cause or didn't find probable cause and then ruled on exactly the same motion. I always felt uncomfortable with that.
Yes, that change was made again to be consistent with the ordinance, and that process was something we had devised to sort of try to streamline the commission proceedings. But now that we're able to hire outside counsel to review these and investigate, that really was no longer necessary.
Any other questions? Or are we ready to either approve or not approve it, or approve it with changes?
I would move to approve it with the proposed changes.
In their entirety?
Yes.
Okay. Second. Moved and seconded that we approve the proposed revisions and amendments. Article 13. All in favor, say aye.
Aye.
Aye. Opposed? Carried. Item 14 is reporting back on fine and penalty policies in some other counties. That's in our packet. Does everyone have that?
14, let's see.
Yeah, here.
We've got 14 years.
Do you need an extra?
Fine penalty, yeah.
Oh, I just found it.
Yeah, well, you're doing better than I
That's
have.
the
I haven't
line
found it yet.
sentence where somebody.
Yeah, here it is.
Yeah.
Okay. Chair Peck and Commissioners, this is a report back, receive and file, based on a discussion from our last meeting about whether or not it might be helpful to receive information about what some other established ethics commissions do in the way of their fines and penalty policies. And I would note that in discussing these with the various staff from those commissions, these policies evolved over a period of time as their specific commissions started to hear cases and pass judgment on them. And I'm not sure that we're maybe yet at the point for us to be able to create our own guidelines yet, since we've really only had 2 or 3 cases that have had
Yeah.
some resolution, but it will at least give you some idea of what has transpired and developed from other established ethics commissions. As you can see, City of Los Angeles, their commission has been around since 1990, so they've had a good long history of resolving complaints. So they started to see a pattern, and that's how, they came to develop, some of their guidelines.
So you've given this as informational. to us.
Exactly. It's really an informational item more than anything else. And I think you discussed at the last meeting wanting to look at your complaints on a case-by-case basis, and from that, try to start to develop some consistency about how the cases are handled. So this is informational purpose.
Thank you. Any comments from commission members on this?
No, thank you very much.
Going on then until, to item 15, yes, excuse me. Receive and file, yes,
Move to receive and file.
Second.
passed. Next commission meeting.
Yes, Chair.
I assume that depending on what you've got in the pipeline, right?
That's correct. We still have 3 outstanding cases to come before the commission, and we're looking at probably not scheduling anything until September because of the month of August being very busy with people taking vacations and so forth. So we'll probably be looking towards early to mid-September for the next commission meeting.
I'll be gone in September until September the 27th.
Okay. We'll make a note of
So
that.
my presence may not be absolutely necessary, but
Well, we may actually have an appointment by then from Supervisor Parks. I don't know yet.
it hasn't been forgotten yet.
No, she's working on it.
Oh,
She's
okay.
got 2 of her three potential nominees. She's looking for a third name. So, but that,
We've got 2 new retired judges now,
Who are they?
Steve Hintz and Barry Klopfer.
Yes. We'll make a note of that.
Don't
Pass
tell
that- pass that
Don't tell
information.
them I pointed them out.
We'll pass that information along to the supervisors. But in any case, we're looking at probably early to mid-September for the next meeting. And we'll contact the commissioners to determine a good date for you.
Okay, is that sufficient?
That's fine.
All right, is there anything else to come before the commission? If not, the meeting is adjourned.
Thank you.